Kalina, we got some breaking news for you this morning. The U.S. Supreme Court ruling that states that can count late arriving mailed ballots, rejecting a challenge led by the Trump administration.
A decision coming down in just the last hours. Justices are wrapping up a term defined by claims of presidential power. Constitutional law expert Robert McWhirter joining us this morning. Robert, thank you for being with us. You're the perfect person to speak to this morning because I often ask you, can President Trump do what he's doing? You often whip out your constitutional book and tell us that he cannot, and it seems the Supreme Court's deciding with you in these cases. Robert, can you hear us? I don't think that Robert can hear us, guys, so we're going to give him 1 second to get his audio together so he understands that we can hear us. But essentially, most of these rulings today were a blow to the Trump administration. The Supreme Court closely divided, 5-4, actually upheld a Mississippi law that will allow those mail-in ballots to be counted even after Election Day, which President Trump did not want to see happen. Robert, can you hear us now?
Oh, I can hear you.
There
okay,
we go.
Wonderful. You couldn't hear
go.
us at first. I was saying I was glad you were joining us this morning. We talked about a lot of these issues separately. You whip out your constitutional book and tell us that it's not constitutional. It seems in many of these cases, these decisions today are a blow to the Trump administration.
Yes, because they're not constitutional.
Yeah.
I mean, it gets pretty simple. By the way, I've modernized. I've now got an app.
There you go.
So
I
we
was
can do
wondering where your book was, sir.
There it is right here. Look, let's just get to this very issue
Yeah.
here about the elections. Handy dandy Constitution app says in Article 1, Section 4, Clause 1, times, places, and manner of holding elections for senators and representatives shall be prescribed by the states, not by anybody else, not by the president. Now, it goes on to say that Congress can make regulations and laws related to elections, but not the president. The president of the United States has no role in the least in determining how elections are run. And the framers of our Constitution did that for one specific reason. The president is the only office that every American votes for. I mean, leaving aside the Electoral College, but it's the only office we all choose. And the framers of the Constitution did not want the person in that office in charge of how he or she was elected. They didn't even give that. They didn't even trust George Washington with that. Why would they trust subsequent presidents? So that's why it is, and that's what the Supreme Court upheld. If the state wants to do mail-in ballots, it's the state's choice, not the president.
Hey, you know, I want to talk about the Supreme Court. They also ruled that Federal Reserve Governor Lisa Cook, she could keep her job. This is while she fights President Trump's efforts to fire her. But they also upheld the firing of others. I mean, can you break this down and what this means for presidential power and how much power the president actually does have?
Yeah, that's a hard one because they have allowed the firing of others, although transitionally. Part of it, I think, is the practicality of the Fed. You don't want to give any president power that the Fed has. You want that independent because any president will manipulate the economy just to make him or herself look good at election time, regardless of whether it's good for the economy or not. I mean, it could be a terrible decision to, let's say, lower interest rates, even though you might like that. But at this, that might lead you to a recession or depression. But for the election cycle, the president looks good. So I think what the court is doing is recognizing that it's a little hard to balance this and the independence of the Fed that Congress created with the other agencies where the Supreme Court has allowed the president to fire people. But those other cases are actually working through the courts themselves. And the court's going to have to square these two rulings up somehow. And frankly, I'm finding it a little hard to see the distinctions between the two, other than the fact that even this court doesn't want to give Donald Trump power over the Fed.
Interesting. Okay, we got one more to talk about, another decision I don't think the Trump administration will be happy about. The court also said it will not be taking up that case to throw out a jury's finding that Trump sexually abused E.G. and Carroll. Talk about the decision there.
Well, the issue that the Trump team raised was that allowing this other evidence of Trump's idiosyncratic sexual behavior and statements was somehow prejudicial to him. There's a specific federal rule of evidence called 404B that allows patterns of a defendant's behavior to come into a trial, whether it's a criminal or a civil trial. So if a person has a pattern of doing the same thing, the jury can hear about that pattern, and that's how this evidence was let in. This was upheld by the Court of Appeals, and the Supreme Court's not going to want to overturn all of that law that allows this evidence to come into a trial. And they weren't going to give the president what he wanted on this. And they weren't going to go to take the remarkable step of overturning a jury verdict on it. If you believe in the jurors, then you just don't do that willy-nilly, get rid of a jury verdict. And so the mechanism exists for a long time, allowing this idiosyncratic evidence in. And so they weren't going to make a big change to the law for Donald Trump on this case.
All right. Well, Robert, hey, thank you so much for the insight. I mean, there's still several high-profile decisions. They're expected to come down later this week. Robert McWhirter, we'll talk to you then when that happens. But thank you so much for joining us.
My pleasure. Anytime.
Yeah, talk to you again soon.